Have you received a DMCA takedown notice and don't know what to do? I'm here to help you out. My name's Joe and I'm an attorney at the Gordon Law Group. Let's get into it. Make sure to stick around to the end. I explain YouTube's and Shopify's DMCA policies in detail. So if you want to know about those specifically, stick around to the end. So first up, what is DMCA? DMCA stands for the Digital Millennium Copyright Act. This act provides a framework for individuals who own copyrighted material to submit a claim against somebody who's using their copyrights illegally. All a copyright is an original work of authorship fixed to a tangible medium. It could be a t-shirt, it could be a movie, it could be a song, anything where there's an original work of authorship and it's fixed to a tangible medium, then it could be copyrighted. What are some common platforms where you may receive a DMCA takedown notice? Amazon, YouTube, Twitter, Instagram, Etsy, and Shopify. All these platforms have various DMCA policies that provide a way for you to respond if you receive a takedown notice. So why was the DMCA enacted? So way back in the day, it was easy to identify copyright infringement. Either a t-shirt was printed, a movie was published on a VCR, or a song was put on a CD or a record player. As soon as that copyright was out in commerce, anybody could see that it was there. Anybody could see that it might be infringing on a copyright of another individual. As the world became digital and everything moved online, it became a lot harder to identify copyright infringement and a lot more difficult to take steps to combat that copyright infringement. Back in 1998, Congress passed the DMCA to prevent the infringement of copyrights in the digital age. All right, so here's how it works. When a copyright holder finds infringement on a platform, they typically look at the platform's terms of service and sees how to provide the notice of the DMCA violation to the platform. The platform then receives that DMCA takedown notice and notifies the alleged infringer of the notice under the DMCA. The alleged infringer then typically has 10 to 14 days to submit a counter notice to the platform, including an explanation why the material does not infringe another's intellectual property rights. Upon the counter notice being provided to the platform can either keep the content removed or reestablish the content and require that the original notice provider has to file a lawsuit in federal court against the alleged infringer. So this process is very complex and often requires attorneys to help you throughout the process to ensure that your rights are protected and you're not being taken advantage of by an over-litigious copyright holder. So you received a DMCA takedown notice from YouTube about one of your videos. Maybe your video had a music clip that was too long that you didn't have the rights to. Maybe you had a video clip in there that somebody else owned. Somebody could have sent a DMCA takedown notice to you for your YouTube video. It's very common. You can either accept the DMCA takedown notice and the strike. As you may know, if you get 3 DMCA strikes from YouTube, your account gets closed down and you lose all of your subscribers and all of the momentum that you've gained from your channel. You should probably look into submitting a counter notice to YouTube. Typically, you have a set period of time before you can submit that counter notice from the date in which you receive the DMCA. Upon receipt of that counter notice by YouTube, you would then be able to have your material brought back up and the strike removed from your account. Granted, if you do submit a counter notice to YouTube, the individual who originally submit the DMCA takedown notice to you can then file a lawsuit against you in federal court. So if actual copyright infringement occurred and you're worried about potential damages from a lawsuit, it may not be in your best interest to submit a counter notice. Similar to YouTube, you receive a notice saying that a third party believes that your content or your products infringe upon their intellectual property rights. You also need to either accept the DMCA takedown notice and have your product removed from the store, or submit a counter notice. If you submit a counter notice, you can get your product back up and running on the store as soon as possible. If you receive a DMCA takedown for one of your products on Shopify, you can no longer sell that product on the platform. Now, Shopify's policies don't explicitly say that if you receive a certain number of strikes, that your entire account gets removed from the platform, but it's obviously best to limit the amount of intellectual property infringement that you have, and you don't want to be receiving these strikes on a regular basis, or else you could potentially lose your ability to make revenue on their platform. Submitting a counter notice to Shopify is a fairly easy process and can help prevent you from earning those strikes. The DMCA procedures are just a way to protect an individual's intellectual property rights. If you're an individual and you're worried about something you're posting could violate the DMCA policy of the platform you're posting it on, make sure to thoroughly read the terms of service and the terms of use for that respective platform. If you're a business and your entire business model relies on YouTube or relies on your Shopify store, make sure to contact a professional to help you review those terms and understand your options and potential repercussions for violating a platform's DMCA policy. If you like this video, give us a like below, leave us a comment, and subscribe to our channel. My name's Joe, and I'll see you next time.